more. If you talk of this mediation, the mediation is for, this particular course is for lawyers, as well said by our director then, Mr. James. This one is different from normal mediation. Like many, I have many issues. Many people have been asking me if the same thing. Some people are saying they're almost the same thing. They are not the same thing. If you look at this material and that material of mediation, they are not the same thing. They are two different things. This one is just telling you the method, the tactics as a lawyer or as a law student or as a practicing mediator, what you use or how you use to handle your issues or handle your mediation problems. That's what this one is just talking about. So as a matter of fact, this particular course is for lawyers, law students, and mediators, people who are practicing mediation. So that's what this particular course is. That's general introduction. Then let's come into the course. This part in mediation will provide you with a complete evaluation of a way to constitute your customers in mediation. The part consists of testing from mediation expert role, simulations, talent demonstration, checklists, and lots more. This online route offers regulation college students, attorneys, and perception into the exercise of business mediation and the competencies they may want to symbolize customers in mediation. These competencies are important for the exercise of regulation and dispute decision with inside the 21st century. Commercial mediation has received a great deal of significance in current years. Most of the events favor to remedy their business disputes amicable and choose ADR mechanism in dispute decision clauses in their business agreements. They regularly are looking for assist for educated legal professionals to help them with inside the ADR process, to sell understanding and gaining knowledge of with inside the subjects of mediation. Also, ADR is to provide certificate knowledge, direction on mediation for 21st century lawyer, for regulation college students and legal professionals. Objectives of study: after studying this, or after listening to my lecture, you should be able to debate, point out of 21st century lawyer, as well as features, benefits, and drawback of the process. Are you ready for 21st century? Are you ready for 21st century legal practice? Learn the skills and the strategies to successfully represent clients in mediation. How to best represent your clients at mediation. A tip sheet. Prepare the case, prepare your clients, hosting the mediation, listen. Really listen. Do not interrupt. No attacks. Use caucus. Where be candid with the mediator. Find out about the latest development in field of mediation and dispute resolution. Introduction. Every successful negotiation calls for which you have a legitimate strategy. In this newsletter, I will give an explanation for the steps that I agree with you must comply with the with growing in a mediation strategy. But to put the foundation for my rationalization, I first need to speak about the threat of a great mediation advocate. As a mediator, I even have had possibility to take a look at many tremendous lawyers who took a strategic method to process all of them, shared those equal threats. Number one, preparation. Number one, preparedness. Just as in trial work, guidance is the key. It is critical which you deliver with you all the ammunitions that you may muster so as to stay the opposite side. Having having a terrific command of each, the data and the regulation will reveal which you are negotiating from a role of strength. It have to additionally make your patron sense assured that she or he is placed to get the high quality to be hard settlement. Openness and candor. Parties will settle instances after they sense that they have enough statistics to assess their potentialities in litigation. Some of these statistics generally wishes to return back from the opposite aspects. Mediation provides an possibility to have a forthright change of statistics in order that no person feels that they are being left with inside the dark. When you are settling mediation, you should do it in a way that everybody should be favored. You should not do it in a way that it should be one-sided. Withholding statistics is typical counter-efficiency can reason the opposite aspect to suspect weak spot for your case. Patience. I had been worried in lots of cases, each as lawyer and as mediator, which require lengthy hours, a couple of sessions, or substantial comply with up painting at the telephone. At a few factor, it could be tempting to surrender in place of saying targeted at the objective. You ought to face up the temptation to hurry the process, willingness to compromise. This attribute is that the most vital of all. No mediation ought to ever be undertaken unless each the professional and therefore the customers are ready to form an inexpensive compromise. Participants should notice that just about each suit involves risk. The party who is said to win is sometimes wasting everyone's time. Herein, I shall table one of the cases I've settled as a mediator. That was the time one of my friends, he was NANS president, NANS means National Association of Nigerian Student president. He's a lawyer too. Sierra Leone was the president of NAMS, Sierra Leone. He's a lawyer now. Then he had a problem with Peace Airline. Then the problem was brought before me as a friend. He told me I should settle the case with them. So when the case was brought before me, I contacted the Peace Airline, the manager of Peace Airline, though he gave me the contact of the head of legal department, who is a lawyer too here in Nigeria, though he's a lady. So we discussed. So as I was discussing with him, so she was annoyed because of my expression. Maybe she was like thinking I was claiming that I know law of contract more than him, because I had to table some matters, what law of contract is all about, elements of law of contract, what vitiate law of contract. So she felt so embarrassed. So after feeling so embarrassed, and I told her I'm sorry, but this is what should be done. So at the end, the problem was settled. It was hard, sir, because my client, he's a lawyer and a friend. What is that his name? Prince Oga John. So Prince Oga John, who was very aggrieved. He could not understand. I was trying to make it the way that the money will be normalized. It will not be too much for AP's line, and it will not be too much. It will not be less than what he needed. Then at the end, the most important thing that at the end of the matter, the case was settled by me, and the money was paid, and he became happy. So that's the most important thing. What matters in mediation, once you are mediating, is how did those both parties, how do they feel? Because as a matter of fact, in this case that I'm just table before you, they settled. After the mediation, they were happy. This guy was not angry. Which is Prince Oga John, who is my friend and the lawyer. He was my client that time. The Peace Airline was not equal angry. Everybody were happy. They just went peacefully. Because the fact of the case was that Prince Oga boarded the plane from here, Lagos, to Sierra Leone. So his luggages were missing, I think about 2. So he claimed damages. As a matter of fact, the case went to the court in Sierra Leone. It was my friend, Aaron. The man is a magistrate now. I handled the case in Sierra Leone. Then he was a lawyer. Now he's a magistrate. He's just like a judge. He even say he's visiting Nigeria. So it was the man that handled it. That was even how we got to know ourselves. I was contacted in Nigeria. That lawyer was contacted in Sierra Leone to handle the case. So after some time, according to the lawyer, said that the client was delaying this, so he left them. So I was contacted again. I was contacted and I was told to contact the lawyer in Sierra Leone. So after the issue, I had to bring told them that this issue has to be settled in a mediation way. So, and they accepted and it was settled. So that is the case. Then the next one is vital steps to successful negotiation. There are 12 essential steps to a surefire negotiation. If that looks like an excessive amount of, remember, it is not. All of the steps are supported with common sense. And if you have got the characteristics that I have represented on the proceeding page, following the steps ought to be automatic. Get to the table. Pick the right time to meditate. Pick the right time to mediate. Choose the right mediator. Have pre-mediation conferences. Set aside sufficient time. Prepare your client. Prepare a powerful position paper. Insist on full settlement authority. Maximize the benefits of the joint session. Set the tune with your opening statements. Get into a zone of bargaining as soon as possible. Don't take a bottom line approach. Get into the table. Too far apart, there are 12 essential steps to a prosperous negotiation. If that feels like an excessive amount to remember, it is not. All of the steps are supported with common sense. And if you have got this characteristic that I have represented on the proceeding page, following the steps ought to be automatic. When I hear this common refrain, I try, and that means that they are the treble reasons why mediation is indicated. If the two sides were already close, then the most likely be able to settle the case on their own. It is exactly as a result of they are therefore paralyzed that they have the intervention of a negotiation. Stories abound of the cases that were thought to be hopeless, however, that also settled at mediation. Here could be a lawyer's comment that I browsed recently. The parties are in proceedings with one another for years. All provisions tried at mediation that had failed. In light weight of this unfortunate situation, I control very little hope that mediation would work. I even have seldom been therefore happy to possess being so wrong. In most of the cases that I have mediated, we tend to begin with the two sides at the opposite ends of the spectrum. Opinion regarding responsibilities appear to be diametrically opposed. Once numbers are placed on the table, the initial provide appears like a token response to the demand. However, the trick to stay speaking as a result of the longer that the parties talk, the nearer they are going to sometimes get a solution. Just to do it. The mediator is not a miracle worker. The secret of their success is knowing that the two sides will never be too far apart to find a solution. Many disagreements are based on emotions rather than reason, and it takes time for emotions to subside. Once their obstacles are overcome, solutions usually follow. Therefore, for parties that do not want to attend meeting, my advice is just to do it. The right time to mediate. In a perfect world, the parties would agree to mediate as soon as possible after the dispute occurs. In the real world, they tend to do the opposite and wait until eve of the trial. When the opposing party faces a deadline concession are usually available. And for most litigants, the deadline will not happen until the first trial. Most people want to avoid the uncertainty of the trial. And as they approach the critical moment, they become more inclined to compromise. Court-ordered mediation. The court sometimes send the parties to mediate before the case is already to be resolved. For instance, there's another case again that was brought before me. I forgot the name of the man, though he always called me my brother. So when he came in respect of the case is a landlord and tenancy case. So when they came in respect of the case, so the case, actually, the client that met me, which always call me my brother, is not the one that he doesn't, according to what he tabled before me, say he doesn't want the case to go to court. I told him that is very fantastic. Let's speak with the lawyer. So what I did was that he gave me the lawyer's contacts. I contacted the lawyer. I spoke to the lawyer that I want this case. I introduced myself to the lawyer first. I told the lawyer that I want this case to settle in a mediation way. The lawyer agreed with me. The lawyer now said the issue is between the tenant and the landlord, that he's not even the problem. That the only thing the landlord wants is for the tenant to pay him. And I said, my client will pay, but he may not pay the full amount of money. Then at the end, the lawyer agreed and said he has to speak with the landlord. And after speaking with the landlord agreed. After that, they prepared the MOU, which means Memorandum of Understanding. Then in that MOU, they agreed that the man will pay so amount of money, so time. After that, the matter was taken back to the court, the magistrate court here in Lagos. It was settled. The magistrate was very happy in respect of the mediation. And courts always prefer mediation method than even court processes. Because most people don't even know that it is a problem. It is always hard, and problem bring all cases every time. Okay, we'll move to talk to opposing counsel. If you are thinking whether or not it is far the proper time to mediate, the excellent manner to discover might be to speak for your opposing counsel. Find out if she or he feels that the case is prepared to settle, and the motive why or not. It also can be useful to have the mediator speak confidentially with each facet earlier to discover if they are geared up to clear up the case. This is exactly what I just tabled before you guys now. Choosing the mediator. The fulfillment or failure of mediation frequently relies upon who the mediator is. Before preserving a mediator, you need to discover as a great deal as you may approximately his or her qualification and methods. Then compare the mediator in mid of every element mentioned under to look if she or he is proper to your case. Style. It is regularly stated that there are forms of mediators, facilitators, and evaluators. Facilitators communicate among the event to be able to assist them attempt a together desirable resolution. Familiarity. There may be from time to time a false impression that the mediator must now no longer have had any previous counting with the event or their counsel. Although the proposed mediator must expose such a relationship, no moral rule precludes the usage of a mediator who is aware of or has treated one or extra of the participants. Many litigators agree with that. The pleasant mediator to apply is the only that the alternative facet is a way off and needs for reason that mediation is much more likely to be successful if the adversaries trust the mediator. Subject matter. Lawyers are usually seeking out a mediator who has know-how with inside the kind of case at hand. This loss of such know-how will create a stepper gaining knowledge of curve for the mediator and might position him or her at the downside while seeking to compare positions. Keep in mind, however, that challenge rely know-how without okay method. Abilities will now no longer make someone appropriate to be a mediator. training and experience. A certified mediator could have gone through formal schooling with inside the technique and feature gathered huge experience, subject rely knowledge without formal schooling in mediation is normally now no longer sufficient. Indeed, an untrained mediator can also additionally definitely do extra damage than good. Pre-mediation conferences. Settlement instances may be challenging, even the small instances. Those that human beings inform me will be simple, can require an sudden quantity of time and effort. In order to make the activity easier, I tend to set up the offset collaborative dating with suggest for these parties. The manner begins of evolve with mediation cell phone meeting among the lawyers and the mediator. In mediation, in contrast to arbitration, expert contacts are totally proper and due to the fact they are part of the mediation. The entirety, this is the stated, is confidential. What to discuss? The essential gadget that want to be included in those meetings are a number of the important steps to fulfill, which might be mentioned on this booklet. Making certain that people with complete agreement authority could be present. Setting apart the time to finish the mediation, setting a date for the exchange of position papers, prepare the client, preparing to make a convincing presentation in joint session, talking approximately the method itself so that everybody might be snug with how it is going to be conducted. Confidential information. A phone convention with the mediator additionally affords a possibility to talk about earlier any facts that could be beneficial in resolving the case. However, they need to be conveyed in confidence. It is very important. How long should it take? Not lengthy ago, I acquire calls from legal professionals who desire me to mediate their instances. One said, we need you to set apart the whole day for this situation due to the facts we really need to settle. The different one said, this is a completely easy way. It shouldn't take a greater than multiple hours, and we need to. Recognize quite speed whether or not it's miles going to be settled or not, no longer. Which of those instances is much more likely to be settled? Preparing the client. Before going to mediation, you need to put together your purchaser. The purchaser needs to apprehend that mediation. It is not like a courtroom docket intending and the need to be clean on the jobs of all the participants. Rather than simple spending a couple of minutes at the telephone. Another one we'll be talking about is preparing the position paper. The function of a function paper are to teach the mediator approximately the character of the case, to illustrate the study factor of your case, and to set the level for a success negotiation. The following recommendation will assist you to put in writing a effective function paper that accomplishes those functions. Move to settlement authority. Don't leave home without it. The maximum not usual place, reason of a fair mediation is absence of men and women with actual agreement authority. Settlement authority method. The authority to conform to something is essential and affordable so that it will cast off the case. limited authority. Sometimes we see consumer representative being dispatched to mediation who purport to have complete authority to settle, however, who in truth have most effectively confirmed authority primarily based totally upon their facets, unilaterally assessment of the case. Any strive with the aid of using the mediator to persuade them that the case needs to be settled on phrases which can be passed that authority is normally fertile. The loss of actual authority is normally obvious to everyone. If the opposite facet is completely empowered to settle, end up justifiable dissolution on the short gamble subject and could likely become bored in similarly mediation attempts. The similar mediation attempt to deliver them again to the vex at a later time might not succeed. The joint session. The mediation have to start with a joint consultation wherein the mediator invitation each to contradict their positions. The mediator must ensure that every person, which includes the customers, has an possibility to talk without corruption. Time will also be furnished for reporter or to pose questions and immediately to the alternative side. The consultation can be primarily time every one of the attorney and the customer, every one of the attorneys and the customer had to have collectively with the inside the equal place, or proceeding conference will probably have been in an advanced context, which includes the position, in which events are confined to answering questions. The joint consultation gives a complete possibility for events to be candid and supply their message to anyone within the room. For maximum customers, it is going to be as near as they get to a day in court. And if the consumer offers properly the joint consultation as a super possibility to exhibit that asset. Airing factual dispute. Parties are commonly pretty positive that they apprehend what the information are, but information are nearly constantly in dispute. Everyone wishes to have a clean photo of what those disputes are about. This is a part of the technique works successfully best while all of the contributors are sitting across the table, having the mediator trip to and fro among caucus to give an explanation for differing variation of the information is inefficient and wasteful of time. The opening statements. Each party delivers a presentation that resembles a lawyer's opening statement to a jury at the outset of the joint session. Although there are some parallels, mediation is not a trial, and there are important differences that must be kept in mind. Speak directly to the other side rather than just to the mediator. The mediator is not a judge at all. Address your remark to the opposing as to counsel. The less legalistic you can make it better. Avoid threats and offensive remarks. Project an air of quiet confidence rather than a sense of righteousness. Discuss the evidence. Try to talk a realistic way about what a fact finder is and likely to conclude from the evidence rather than about what really happened. Give an effective reply. Ask the mediator to provide you with an opportunity to respond to the other side. Use this time to summarize their argument, showing that you listen carefully to what they have to say, but pointing out where you disagree. If there are areas of agreement, be sure to mention them. Reiterate your client's interest in settling the case. A strong police can establish the tool for mediation is to on ideas or claims. The focus should be on the facts. Above all, refrain from making aggressive remarks. It may be tempting to use the joint session as an occasion to vent or frighten the opposing side. But consider this. With these strategies, persuade people to see things your way, or will it serve to cement their resolve, demand, and offers, starting at the extreme? They want to know how much. I think we are just wasting time here. Their case is worth anything close that. You mean this is all they intend to offer? I don't think they want. In their the most frequently here this was. Okay, let's move to the next one. Getting ready. At the same time, a professional mediator will encourage the parties to come up with numbers that are rational related to the value of the case as soon as possible. The zone of bargaining. Before a case can be settled, the parties must, in a negotiation area in which demand supply are both too justifiable in light of the case. That means getting into the zone as soon as possible will make the process easier for all. Someone has to make the first step, and it will be the requester. The bottom line. When preparing for mediation, a client usually wants to talk to his lawyer about what the bottom line should be. Why it is only natural to take this approach, it is not necessarily productive. Parties who start with the bottom line approach often to mediation with unrealistic issues in order to make progress towards resolution. We have to set those notions aside. A learning experience. The process of mediation is a negotiation, but it is also a learning experience. Information will come from the other side that may affect the evaluation of the case. The mediation will be asked to give opinion on the relative strength and weakness of position. Determining value. The true value of any lawsuit in a manner that is similar to the valuation of an asset. Fair market value is determined by a buyer who accept and what a willing seller will pay. The number that an appraiser would give may be reasonable, accurate, but it doesn't represent actual value. In like manner, the value of a lawsuit can only be determined through negotiation. Number that the plaintiff is willing to accept and that the defendant is willing to pay is what is the case was. 21st century Nigerian lawyer. For many years, lawyers have been an integral part of society and have shaped both social and economic aspects with the true tools of written and spoken language. As a result, society has evolved through many changes in rules, regulations, and guidelines. Change is generally an unavoidable factor in any society. However, legal profession is often claimed to be identified as a part of society that is often reluctant to accept and adapt to change. This is not far from the truth. For hundreds of years, despite many changes in society, lawyers have succeeded in defining relationship with client and society as whole using the same business model. The 21st century introduced within the waves of globalization and data innovation, which has caused diverse changes within the socio-economic climate in each society all around the world. As a result, the mode of doing commerce has been changed from what it utilized to be, with the unused trade thoughts, improvements, and developments springing up each day. Not all disputes can be resolved through ADR, but disputes that can be easily resolved through ADR are contained in already overcrowded files of most courts. Recently, various institutions have been set up to support the promotion of ADR in Nigeria. An example is in Lagos Arbitration Court, an independent, private-owned international center for resolving commercial disputes through arbitration and other forms of alternative dispute resolution. Also, although not in all federal states, the judiciary has somehow introduced other means of dispute resolution by organizing agencies such as Lagos Multi-Door Courtroom, the Civil Mediation Center, such as Lagos Reconciliation Week. There's one in Enugu. It is a multi-court room in State High Court in Enugu too. The new Lagos Civil Litigation 2019 regulation are primarily aimed at promoting ADR. This is because the matter submitting to the court must undergo an ADR review before being assigned to a judge. Good. Matters that were pending before the new rules were announced can also be sent to the Lagos Multi-Door Courtroom by judge handling them. With the creation of synthetic intelligence into the commercial enterprise world, you will be able to be best desired that inside the subsequent couple of years, the so respected felony career will now no longer lose its relevancy due to lawyers' unwillingness to involve to the change. If you look at the material says that in Lagos now, before there is some cases that will bring, they will not treat it. It has to go a mediation process before it can be handled, because some people are wicked. Some people would like those people to go to jail. Some people would like them to be compensated in a very huge amount. They will say, I'm not comfortable with mediation due to they want to wicked the opposing party. So that's another thing that makes them to go to court direct. But now in Lagos, you must also go to mediation method before coming to court. In conclusion, mediation is an alternative dispute resolution method, has been around for a long time due to globalization of business transactions and the ability of the parties to harmoniously resolve disputes arising from such transactions. The mediation process is becoming increasingly popular. A good deal is better than a good proceeding, said Abraham Lincoln. The fact that the majority of civil proceedings have been resolved shows that this advice was taken into consideration, and the widespread acceptance of mediation shows that mediation is an excellent form of dispute resolution. In order to reach a good settlement through mediation, lawyers must take a different procedure than in courts. The use of process management skills in mediation is not appropriate. Trading skills provide better service to lawyers. If you are carefully prepared, honest, patient, and willing to compromise, you will find the mediation works well for you and your client. Well, we've already discussed what mediation is about, the steps to take, the secret of mediation, what you need to know, some of the law that are guiding mediation, especially in Nigeria, Lagos, Nigeria, to be precise, and many others. But know that mediation cannot settle every other cases. Like any criminal matter is ultra-vires to mediation. Ultra-vires means beyond the power or jurisdiction of mediation. Thank you, I'm done. If there's any question, please ask. Thank you.
Okay, I have a question, Mr. Charles.
Okay, go on.
I'm so much pleased for having listened to you for the past 20 minutes or so. I've learned a lot, but my question has to do with you made mention of court referred to mediation. What is the effect of the outcome of a mediation that have been referred to by a court?
What is what?
What is the effects? You made mention of a court referred to mediation during your presentation, and I'm saying that.
Okay.
What is the effect of the mediation's outcome against the court's proceedings?
I said the reason is this, you know, court are having much cases at hand. So they always like you to go to mediation first before coming to court. But the most important thing is that after court referring you to mediation, maybe multi-door mediation or any of the, because you have many names they can be named. After that, you have to bring that agreement at the settlement to court to take a perusal on it and make sure that it was done very well. Did you get it?
Okay. Yeah, I get it.
Yes.
Now.
Court will still see it after everything. They cannot just do it after that. You take it to him. No. Court has to finalize.
Okay. Is the court finalizing the decision they've arrived at to make it binding and adopt it, or how is
Adoption.
the finalization?
Adoption. They will adopt it.
Okay.
I just told you there's even the recent one. It's not even up to a week. I did. There's a landlord. Okay, you know that you know you say you came in next 2 minutes. Yeah? I said there was a case I mediated here. The case is case of landlord and tenants. A client met me after telling me the situation, so I had to call the lawyer. After speaking with the lawyer told me that the case is not on his own hand, that the case is between him, the tenant, and landlord. That they have to settle. That it doesn't have any problem with them. So, and my client said that he doesn't need court, that he needs mediation. That was why I called the lawyer. I told the lawyer, this is what my client needs. So the lawyer and I agreed. Then we consulted the landlord. I wasn't the one that spoke with the landlord. It's the lawyer that spoke with the landlord. Then after that, they called themselves out. That morning, they were there by 7. They settled the case and have what is called MOU, Memorandum of Understanding. And they agreed that the man will pay so time. The case was set. It was taken to court. Court was happy.
Okay.
Did you get it?
Yeah.
So that is it.
I get it. So that's the only question I have for this session. Thank you very much for the clarification.
Yeah, welcome.
Yeah.
Okay, now. Okay,
so
since in absence of no question, I think you have to end the lecture.
Okay. Then thank you so much, Mr. Charles, for the time you spent with us. And I hope people are going to learn a lot of things from what you've told us so far as mediation for the 21st century, like for lawyers is concerned.
Yes.
I also have to remind our participants that we are live on Facebook, and it is going to be posted also on our YouTube channel, and everybody can have access to it and learn from this wonderful lecture, and very insightful one indeed. So thank you so much, Mr. Charles, and have a very good evening. Good evening.
Good evening to you too. Yeah. Bye. Yeah.